Hello, I'm Tom Cross. Welcome to Cross Examination. I'm a barrister in London, working on cases with cultural, moral and ethical importance. In this podcast, expert panellists join me to take an independent look at the law surrounding one of these issues. Caversham Primary School is a mixed, average-sized state school in Reading, which had been graded outstanding by Ofsted for many years. In November 2022, Ofsted inspected it, deciding that it was good in all but one area because of its safeguarding processes. But under Ofsted's current inspection handbook for maintained schools, this meant it merited an overall rating of inadequate. Tragically, before the report was published, the school's head teacher, Ruth Perry, took her own life, a suicide contributed to, as a coroner later found, by the November inspection. A few months later, in June 2023, the school was re-inspected and labelled good, with inspectors observing that the arrangements for safeguarding were effective. The case naturally raises issues about the manner of inspections and whether policies adopted by the inspectorates, including on grading, are fair. But they also give pause to consider whether the processes for challenging the application of those policies by inspectorates are adequate. In the particular case of Ofsted, is the natural power imbalance between regulator and regulated weighted too heavily to the former, and are changes necessary to ensure fairness for schools? Cross-examining with me today are, as always, two of the country's most expert lawyers in the area. Michael Brotherton is a partner in the education team at leading law firm Stone King. He focuses predominantly on operational aspects of school life, including pupil-parent issues, Quality Act claims and governance, as well as acting on challenges against Ofsted. Hi, Mike.
Good morning, Tom.
Emma Swann is an education partner and head of academies at the law firm HCR and has been advising schools on pastoral, governance and commercial matters for over 20 years. She's also a trustee and sits on the board of the Institute of School Business Leadership. Hi, Emma.
Hello.
Michael, let's set up, first of all, how the system currently works. So, like a lot of regulatory regimes, you have a mixture, as it were, between law in the form of legislation, but also an awful lot of policy under which Ofsted and other inspectors do their work. First of all, let's go to the very basics. What is Ofsted, and is it the only regulator that inspects schools?
So Ofsted is it stands for the Office for Standards in Education, Children Services and Skills, and as one might expect from its name, its role is to inspect services providing education and skills for learners of all ages, as well as inspecting and regulating services that care for children and young people. Can I just touch on independent schools?
Yep.
With independent schools, there's a sort of a dual process in many ways. So it does inspect independent schools, but routinely those that are not members of associations affiliated to the Independent Schools Council. Whereas those independent schools that are members of affiliated associations, well, they're inspected by the Independent Schools Inspectorate, or ISI as it's colloquially known. And that, I think, is approximately half of independent schools. And one final note on independent schools is academies are strictly independent schools, but because they're state-funded, it is Ofsted that routinely inspects academies.
Yes, they'll have a contract between them, the trust usually who runs the academy, and the Secretary of State, but they are state-funded through that contract. What about Ofsted? If we just focus on Ofsted, Michael, where does its power come from? Is this in legislation? Is it somewhere else?
Its powers derived from statute. Essentially the Education Act 2005. There are other acts that touch on their powers. But the 2005 Act sets out various powers and duties. So first, Section 5 of the Act gives Ofsted a duty to inspect at set intervals, and typically the maximum is 5 years from the end of the school year of the last relevant inspection. And it requires it to make a report of the inspection in writing on the quality of education provided at the school. So, for instance, the November 2022 inspection of Caversham Primary School that you were referring to earlier, that was a Section 5 inspection, and they're often referred to as graded inspections. The quality is graded on a range of outstanding to inadequate, which I think we'll touch on a bit more later.
So periodic ones where Ofsted has to do it at prescribed intervals.
Indeed. And then the 2005 Act sets out that the inspection report must cover 4 specific areas. So the achievement of pupils at the school, the quality of teaching in the school, the quality of leadership in and management of the school, and finally the behaviour and safety of pupils at the school. And if the school has sixth form or early years provision, then the report will touch on those two specific provisions as well.
So the law is saying you have to cover in your report these 4 areas. That's
Correct.
what the statute says.
Yes.
And then there's going to be an awful lot of policy framework around how they do it.
That's right. I mean, it's interesting that legislation says very little about what Ofsted must cover, and perhaps more interestingly, about how they go about the inspection. So whilst you have a legal requirement for the inspection to cover those 4 specific areas, any framework or policy that Ofsted has must work alongside statute in that regard.
And the ISI, which you mentioned, a separate inspector, looks at what, about half of private schools or independent schools?
It's about that, yeah, that's right. But the ISI will look at, so for independent schools, they have the independent school standards regulations, which are a set of standards that are minimum standards that an independent school must meet. And in many ways, it's far more prescriptive as to what a school must do. There is a schedule to those regulations which set out what an independent school must do in order, in essence, at its utmost, to remain on the register of independent schools, and that's what the ISI is looking at. Can I just go back to Ofsted and statute? So we've talked about Section 5 and graded inspections. Also under the 2005 Act, Section 8, you have another route for inspecting schools. They're often known as ungraded inspections, and they can either be inspected pursuant to a request by the Secretary of State to Ofsted, or where Ofsted decides to inspect even when not required by law. And an example of that is, for example, Ofsted may receive what's known as a qualifying complaint, and there may be specific concerns at the school. So Ofsted would go in under Section 8 and carry out an inspection. And with Caversham, so you also have monitoring inspections under Section 8. With Caversham, in the follow-up report in 2023, that was carried out under Section 8, but Ofsted upgraded that to a Section 5 so it could grade the school, again, on the range of outstanding to inadequate.
So think about the difference between the two inspectorates. If I'm one of those independent schools that is inspected and regulated by the ISI, I have to comply with these things called the independent school standards. That is, in fact, legislation, quite prescriptive legislation, as you mentioned, that says in terms, under separate paragraphs, under separate themes, if you like, what the standards are that have to be met. The case isn't quite the same, Emma, in relation to Ofsted, for whom the legislation says very little, but there's a huge amount of policy framework about what those schools, the great majority of schools that Ofsted inspects, have to comply with.
Yes, Tom, you're absolutely right. So I think probably the perception is that the law is nicely set out in statute, but the reality is that you often have to look for the detail in the guidance. So in terms of Ofsted, there are essentially 2 key policy documents. Those are the Education and Inspections Framework that was, it came into effect, it was recently updated, it came into effect on the 1st of September last year. Now, that describes the principles under which Ofsted operate and the main judgments that inspectors can make. So there's a 4-point grading system. I expect most people are going to be familiar with this. So in essence, grade 1 is outstanding, grade 2 good, grade 3 requires improvement, and grade 4 will be inadequate. Now, the framework also sets out key judgments that can be made, and these basically look at the quality of education, behaviour, personal development, and leadership and management. So just to give an example here, the framework says that in assessing, for example, behaviour, inspectors will make a judgment by evaluating the extent to which a school has high expectations of behaviour and applies these consistently and fairly. The framework also then sets out how a judgment can be made as to overall effectiveness of the school.
So you have some level of detail in the framework, the so-called Education Inspectors Framework, but there's also a large number of inspection handbook documents which inspectors use and schools see with more detail.
You're right, Tom. So alongside these, there are the inspection handbooks. Now, these can apply to particular settings. So, for example, there is one that's applicable for maintained schools and academies. Now, these contain more detailed information.
Yep.
So, schools, as you say, can get a level of help and support as to what they need to do to secure a particular judgment. So if you take, for example, the Handbook for Maintained Schools and Academies, in there it sets out that a school will actually receive an overall rating of inadequate, where one of the key judgments is inadequate, or indeed, as you'd referenced earlier, if safeguarding is ineffective. And that's obviously the key issue that was applicable in the case of Ruth Perry.
I see. So the handbook will tell you how the ratings work, whether or not you can be failed overall. I say failed, can get an inadequate rating overall if you get one thing wrong, and broadly how the different judgments feed into the overall grading. But in other words, if the inspector judges safeguarding to be ineffective, no matter how brilliant the school is in all other respects, it must receive an overall rating of inadequate. That's what you get from the inspections handbook.
That's right. And that's obviously the contentious point here. And then you have to think about the consequences for any school of receiving an inadequate rating.
What are the consequences of getting an inadequate rating?
Obviously, for the school, the report's going to be published. There's going to be an immediate impact on the school's reputation. What will happen is that Ofsted will report that rating to the DfE. That effectively starts a chain of events. So if we're talking about maintained schools here, if a maintained school is judged inadequate, it may then be required to convert to academy status. If it's already an existing academy, then what will happen is that it may be rebrokered to another trust.
All right, so thinking back on inspections, you have a detailed policy framework in Ofsted's case, under which inspectors are required to make judgments about a school. But what about when the system goes wrong? Simon Larter-Evans was previously the head teacher at St Paul's Cathedral School, a choir school whose governance arrangements are unusual. He's now principal at Tring Park, a specialist performing arts school. I spoke to him and asked him to explain an issue which the ISI had identified with his former school. Let's have a listen.
The legal difficulty was about determining proprietorship, who determines the policy and practice in the school on a day-to-day basis. So the question was, who was being judged, the school or the cathedral? And then for us, that raised a question of, well, where's the jurisdiction of the inspectorate? And it's a problem that faces a lot of choir schools. Most of them are attached to or are closely associated with religious foundations of some form, college chapels, cathedrals, abbeys, that kind of thing. And what we've seen is that the ISI's interpretation of what proprietorship is, given that it is really complicated in those kinds of foundational relationships, can be inconsistent or can appear to be inconsistent. So just agreeing that definition was problematic. Then the problem becomes, if we then failed on an unanswerable legal point, well, that starts to feel Kafkaesque, given that there was then no willingness to enter into dialogue outside of a written complaints procedure. And I know we're sort of going on to that.
So I'm particularly interested in the process that you found yourself in and your response as a school to that process. You find yourself in disagreement with the inspectorate. It's a technical legal problem. What could you do? What did you do?
Yeah, so your recourse is to then complain initially, or you can take the report as it is and manage any potential damage that might come out of the back of that. And it was really, what was one of the kind of ludicrous moments is that when we presented the idea that a failed inspection had the potential for reputational damage, the response that we got through the complaints mechanism was that claim of risk to reputation was then not upheld. So when that's the answer, you're working against this extraordinary Orwellian machine. It's sort of funny in hindsight, but it certainly wasn't at the time.
What particular challenges did you feel that you faced as head teacher with a complaints process of that nature?
The frustration was that our complaints were simply not upheld without very much reason or discussion. And there's no satisfactory way to resolve that despite us asking for dialogue. We wanted human beings in the room, and the only mechanism for us was through writing. And apart from anything else, it's such an enormous waste of time. So what you then have to do is that forces you to pursue the complaints process to its natural end, to stage 3. And then something even more frustrating happens, is that the inspectorate selects its own independent panelist. It's never revealed to the school who that person is. The evidence base that the panel relies on is not shared with us. So actually then we're in a position of simple breaches of natural justice as we saw it. And that was maddening, because schools are held to much closer account on how complaints are managed. And you can be failed on that. Now, I do understand that inspectorates are looking at how complaints are dealt with, but even with more finessed quality assurance processes in place, there's a high degree of appearing to mark their own homework. Ofsted has an outsourced resolution system, which I've not tested, so I can't comment on its efficacy. But even then, what's reviewed is whether due process was followed. So there's no other mechanism than a very public judicial review for arguing against the specific judgment.
Michael, Simon Larter-Evans describes an issue that his former school had. In that case, it's a question about the applicable law, on which there was a clear difference of opinion. The inspectorate says one thing and the school says another. And schools in that situation, whether it's a legal issue or not, have to decide what to do. Just help us by drilling down into what are the options available for a school when it simply disagrees with what an inspector is proposing to find?
The position is broadly similar under both Ofsted and the IFSI regime, and it comes down to 2 basic choices. Yeah. And those are to complain or seek a judicial review. And you would seek a judicial review after complaining under the principle that you have to exhaust all other available remedies. Yeah. If we focus on the complaints aspect, that's governed by Ofsted's own policy. Again, it's not law, and this policy again has been recently updated, so 4th of April. So for issues post 4th of April, the policy in terms says that you should try to raise concerns during the on-site visit, which could include telephoning a senior inspector during an inspection. If that doesn't work, you can seek a review of the inspection process, which includes inspector conduct and judgments made, by submitting a formal complaint from when you received the draft inspection report. So there's been a bit of a change there. It used to be when you'd received the final inspection report, you'd submit your formal complaint.
But just pausing there, Michael, you can therefore complain about the judgments made by the inspector, but you must complain about it to Ofsted.
To Ofsted, absolutely. And Simon used a very neat phrase, which he referred to marking its own homework, and I think that really does apply, because the process is very much behind closed doors. You don't know what's going on. You don't know the basis on which Ofsted is reviewing the complaint. But just to go through the process and how it works out, Ofsted will now withhold the publication of an inspection report whilst the complaint is being considered, and then they will send you the decision letter of the complaint and publish the final report within 5 working days. So you have a very small window to react to the outcome of your complaint and the final report. If you remain dissatisfied, remember the final report is now going to be published irrespective of your views of the outcome of the complaint. You can then go to the Independent Complaints Adjudication Service for Ofsted, which almost ridiculously will only review the handling of the complaint by Ofsted. So if Ofsted have complied with its own complaints policy, it's a pretty toothless mechanism. It cannot expressly overturn Ofsted's inspection or regulatory findings.
So you can't look at the judgments that may have been the foundation of your complaint in the first place. You allege a particular judgment is unfair, let's say it's completely unsupported by the evidence, to take an extreme case. That's your allegation. Ofsted disagrees itself, but there's nobody then to go on and look at that issue.
Yeah, absolutely. And there is also recourse to the Parliamentary and Health Service Ombudsman, but again, that's only concerned with maladministration. So it's a very constrained complaints process in terms of actually focusing on the issues that the schools will be concerned about.
Now, what about judicial review? You mentioned judicial review. What is that? We should explain first of all, and what are, if you like, the pros and cons for a school in broad terms of going down that route?
So in basic terms, it's a legal mechanism, a type of court proceedings where a judge will review the lawfulness of a decision or action of a public body, so in this case, Ofsted. And it's a challenge to the way in which a decision has been made rather than necessarily the rights or wrongs of the conclusions reached. And you will bring a claim principally on three general grounds. One could extrapolate that further, namely that the process was illegal, that the decision was irrational on the evidence before it, or that there was procedural impropriety that effectively led to a flawed outcome. But I think what's important is that a court won't impose its own decision. Yeah. So you won't have a judge saying, well, this school should be graded outstanding in all areas, for example. At best, you'd have the report quashed and remitted back to the decision maker, Ofsted, to start the process again. And I think one of the major drawbacks, and I think this goes into your second part of your question, whether it's realistic and what are the drawbacks. Well, of course, it will depend on the facts of the case as to whether it is a realistic challenge to bring. But in principle, it is a very high bar to challenge Ofsted. Perhaps understandably, Ofsted will defend its reports robustly. So school is looking at committing many thousands of pounds to litigation where you have an inherent litigation risk in any event. And further, of course, if you're unsuccessful, you may have to meet a significant costs order. So perhaps understandably, schools will err on the side of caution. And I think it's fair to say that Ofsted knows this. It knows that schools will be reluctant to challenge. And that doesn't lead, I don't think, to an effective process whereby a public authority should be properly held to account for the work that it is carrying out.
So there's no process by which, for example, an independent tribunal could look independently of Ofsted and ask itself, an independent person asking itself, do I agree with the judgment of Ofsted, which goes to really the central critique in this area, that there is just simply too much, Emma, of a power imbalance between this particular regulator, goes the criticism, and those that it regulates. The processes start from the point of should I or shouldn't I uphold a judgment that somebody else is making. There's no process for another independent person to look afresh at that judgment. Is that your experience with clients? Is this something that comes across in the casework you do?
Probably more broadly, what we see day to day is that it would undoubtedly be preferable if schools were given access to the evidence on which Ofsted is actually making the judgments. So if that was available before schools were submitting complaints, that would obviously, from our perspective, make the process far more transparent and also help with bringing a robust challenge. So if I take, for example, we were recently acting for a home education setting. Now, this had been deemed by Ofsted to be operating unlawfully as an unregistered independent school. Those were the concerns that were being raised. So the reality here was this was a setting that was actually doing a great job on the ground supporting parents who were home schooling. Now, they were told that it was considered that they could be operating as an independent school. However, there's no actual explanation given by Ofsted as to why that conclusion is being reached. And I think that goes to the heart of it. They're not being given that information and that evidence. So what that means in reality is that to mount a challenge to that, and we did successfully mount a challenge, but you have to effectively argue Ofsted's case. So you were saying, well, if your reasoning is X, our challenge is Y. And if your reasoning is something else, here's our challenge to that point, but we don't know what it is. But we're essentially looking at this, reviewing it, considering what we could potentially think Ofsted's grounds are, and coming back and mounting a defence. Now, that's doable when you've got lawyers involved, but my gosh, doesn't it make the whole process much, much harder for the schools involved or the settings involved here?
If you choose to complain about an Ofsted judgment, or perhaps you're deciding whether or not to complain about an Ofsted judgment, you will not be given, even if you make a complaint, what is called the evidence base, the basis on which the inspector's notes effectively, on the basis of which they have made the decision to give you a particular rating. How can you complain about a rating if you're minded to do so without understanding the basis on which, the evidence on which, the inspector has arrived at that judgment?
It's a complete imbalance, Tom, and I think actually it extends beyond the complaint point. It extends even once you've gone through the complaint. If you wish to mount a challenge through judicial review, you will not get the evidence base pursuant to your pre-action protocol letter. You will not get the evidence base pursuant to a freedom of information request. You will not get the evidence base, even if you undertake to keep the information absolutely confidential. You simply will not see it. Ofsted will, as a matter of course, delay for as long as possible before releasing the evidence base to you. And that seems to be almost absurd, because if Ofsted, in performing a public function, are exercising their expert judgment on the evidence base before it, surely they would be able to justify that and should be transparent about the evidence base on which they have reached those judgments. But I'll give you a little anecdote. We acted for a school it's a few years ago, and the school, having seen the draft report, it was in the days that you would comment on the draft report and you would only then issue a formal complaint on the final report. But they were convinced, having read the text, that that it was based on a different school, that part of the outcomes were based on a different school. We made a request for the evidence base. We were denied. The school decided they didn't go down the complaints route, interestingly. They just thought, well, let's just focus on improving what we're doing. Once your ability to challenge an Ofsted report has expired through time, through a fluxion of time, Ofsted will release the evidence base, and lo and behold, when the evidence base was released, it was indeed the case that there'd been a mix-up in information about another school that particular inspector had also been inspecting, let's say a week previously. So it was farcical, and it's almost laughable, but in fact it's very serious, and it's very important, I think, for schools that they should be able to see the bases on which Ofsted are making judgments, which can have far-reaching consequences in themselves.
If you're not going to do a right of appeal, the question might arise as to how to improve the complaints system. Let's listen actually to what Simon Larter Evans said about that when I asked him how he thought that could be done. Standing back from it, Simon, can this complaints process from a school's perspective be improved? How could it be improved?
I think it really could, and actually quite easily, at least from our perspective, from a school's perspective, that can be improved simply by introducing a process of dialogue post-inspection. The idea is that dialogue happens at the time of the inspection and that moot points are covered off when they're with you. But when that fails, and this sometimes gives rise to heads occasionally feeling that inspectors arrive with a predetermined outcome, whether that's true or not, it certainly can be the feeling. The process of complaint then becomes maddeningly bureaucratic. In our case, nothing substantive had changed since the previous inspection, neither had the law or the Education Act, yet the agenda was different and the rationale we felt was spurious. And we could see it coming because our colleagues in other settings had been through the mill on this one.
Emma, I wonder about the idea to introduce mandatory or usual dialogue after an inspectorate has said we're minded to find a problem. I mean, isn't the fact that the inspector has already made that judgment a difficulty there? It's not supposed, is it really, to be a process of conversation whereby you try and persuade an inspector to the opposite view? Or am I being unfair? Could one see realistically a regulatory world in which you could have that type of persuasive conversation with an inspector before a report is published?
I can understand your point, but I think dialogue post-inspection can be helpful to some extent. I mean, if we look at some of the recent changes, so schools can actually expect now to be contacted on the telephone by an investigating officer to discuss their complaint. And in terms of that, I think that's actually a welcome change to the process. So I think generally for schools, the fact that they have the chance to actually speak to someone, to explain the reality of what happened on the ground, to clarify any issues, I think that can be a lot more helpful than simply what can be conveyed in an online form. However, of course, that's obviously very different to a formal process that we may want to see that could actually be ultimately far more effective and fairer to schools if there was that element of an independent appeal that could actually look into the issues at stake and ultimately have the power to quash a judgment.
And this question, Michael, first of all, about one-word judgments that's been in the news so much, which has dominated a lot of the present debate. There seem to me actually to be two potentially separate issues here. One is the one-word judgment simply too simple? Does it obscure necessary detail to enable a parent, for example, to find out what a school is really like? The sort of simplicity question. But then there's a different question, isn't there, which is whether it can be right that if a school fails on one single thing, in Caversham's case, safeguarding, as the handbook says, that is sufficient to give you your overall judgment of inadequate. That's a question about whether it can be right to get an overall judgment based on one particular aspect of a school's operation going wrong. The latter is certainly something that Ofsted could fix overnight if it wanted to, but it's not presently indicated it's going to.
Safeguarding is the golden thread of inspection, as it's called, and very sadly, all too often we see reports in the papers of where safeguarding has gone wrong. So I think it is right that Ofsted approach safeguarding with due rigour. There has to be an element of common sense. So the question is, what are the safeguarding issues? Do they compromise the safety of pupils? Yeah. And I think Ofsted are listening a bit more insofar as now if there are minor issues that can be corrected before the end of the inspection, then safeguarding will be deemed to be effective. If they are issues that will need to be corrected but won't be able to be corrected before the end of the inspection, but could be corrected within a short period of time, Ofsted will be returning in any event within 3 months. So it does give the school a chance to correct the record, so to speak, within a short time frame, such that it may not have the impact on its reputation that it might otherwise have had prior to the change in process. But I come back to the point that we have to be very careful, because fundamentally schools are looking after vulnerable young people, and we have to get safeguarding right.
So this question of safeguarding was an issue, or the relationship between a single element of a school's operation, no matter how important, and the overall nature of a school's operation was something that Emma, the coroner in Ruth Perry's case, picked up on. I just want to explain exactly what happened there to listeners. She made the point in her report, which was called a Regulation 28 report, that she sent to various parties, which illustrated matters of concern that she had as a coroner about the case. She noticed that a school that was, as she put it, dreadful in all respects, a thoroughly bad school across the board, would get the same rating under the current policy as a school which was good in all areas, as Caversham indeed was, but had, as she put it, safeguarding concerns which could be remedied quickly. And I just want to be clear about Ofsted's response to the coroner's report as it stands at the moment. We recorded this in May 2024. It said in its response to the coroner's report, this is 19th of January 2024, it said, "We've introduced the opportunity of a rapid re-inspection process within 3 months. This will allow, they say, the school to put matters right and have its grade changed swiftly." And it also said it'll consider this through its so-called big listen that it's engaging with at the moment, that it's undertaking, its consultation it's doing at the moment. I wonder, Emma, I mean, I'm not sure whether that is rightly or wrongly quite what the coroner's point was. I think she was concerned, the coroner, about the unfairness at the time of inspection, rather than the question of putting right in the future. The unfairness at the time of inspection of treating those two schools in the same way. And Ofsted's response, at least at the moment, seems to me to be to say, well, if that's the position at the time of the inspection, fine, but the remedy is to lean on the school to get it to make the relevant adjustment within 3 months. It's not quite, it seems to me, meeting the coroner's point, which is that it is wrong in principle to grade those two schools differently at the time of the inspection. I don't know whether you agree with that.
I think in the simplest terms, most people are going to look at this and consider you can potentially have two very different schools, both of which will end up with an inadequate judgment. One, because it's wholesale failing on a number of different areas, and another that can be performing very well, but as you've said, has fallen down for some reason, even if it's potentially a more technical point in terms of the safeguarding. However, I suppose that ultimately brings us back to the points that Michael has made here, that safeguarding is effectively the golden thread. Yeah. And we're obviously, we're looking at this and we're having this conversation as lawyers, but also, for myself as a parent, actually you want schools to be held to a high standard in terms of safeguarding. So the question here is, what can be done to make it more fair? I think there has been movement, as you've said. Ofsted has now said, return within 3 months. That does give schools the opportunity to make some changes, and also to probably avoid the need for formal intervention being put in place if those changes can be brought in swiftly. I think, as you mentioned, as part of the big listen, this is what we're going to have to see what actually comes out of the process. So as I understand it, Ofsted will now be considering whether it actually would be appropriate to withhold the judgment of inadequate whilst the school is given an opportunity to remedy those concerns. And if we're looking at a relatively short period of 3 months, it will be interesting to see what the result of those consultations are.
Let me think for a moment now about the separate question of inspection culture. There was obviously a question in Ruth Perry's case about that. Let's have a listen first actually to Simon Larter-Evans' take on the culture that's adopted by the inspectorates during inspections.
Inspections are by their very nature interrogatory, and the conduct of the inspectors makes a big difference as to the way that manifests itself. Most inspectors are either current heads or former heads, so you'd imagine there's a high degree of empathy, and there often is. It isn't always the case. They can appear delightful in the catch-up sessions. So every day there's a moment when the leadership and the lead inspector come together and say, how's it going? What do you think? And then when they're talking to staff, it can be perceived for them that they're very different, and staff can feel intimidated. So the idea that inspections are universally supportive is not quite right, and it can sometimes be the case that members of the inspection team simply don't have the competency to understand what they're actually looking at, and this is particularly in the case in settings like these, like choir schools or performing arts schools, where there's a highly specialised part of what we're doing, and some of this inadequacy in understanding is then revealed in the report's narrative. And I've done this. I've compared reports written by inspectors that know the territory against those that don't, and the difference can be really marked.
We've had the very sad case of Ruth Perry recently, whose mental health was found to have been affected by the way in which, in that case, Ofsted approached its inspection of her school. I wonder, as a fellow head, how you responded to that story, what your reflections on it are and were.
Yeah, I mean, Ruth's death is a terrible permanent agony for that community and her family. I don't know what the circumstances were precisely for Ruth, but a general observation, and in part from my own experience, is that heads and their leadership teams and their staff and the families educated by them care really deeply about their schools. And where there's a failure to understand the context of a setting, when you're in the room with the inspectors who clearly don't understand or might appear willfully committed to a process despite countervailing evidence, then it's a recipe for tremendous stress. So when you're at the absolute mercy of another person's judgment, about which there may be evidence for at least to share some dialogue towards different outcomes, which are then denied you through the complaints process, that's really paralysing. So when you complain or attempt to rationalise the inspectorates, what we found is that they either won't engage or simply cannot be wrong, and there are no words that can describe how that feels. And people lose sleep and their health deteriorates.
Michael's explained the sheer breadth of institutions, the tens of thousands of institutions of all sorts, different sorts, going beyond educational institutions indeed, that Ofsted inspects. Is there a case, I wonder, for greater precision in who is the inspector in a given case? Should individual inspections have particular specialisms relevant to a school before inspecting it?
Absolutely, and I think Simon's right. What he says makes sense. I can just speak anecdotally as to what I've heard, particularly in the case of special schools. So there, we've worked with schools who have said that they've been asked questions that, quite frankly, don't make any sense in the context of a special school. So I think with the particular nuances that you have there, or indeed in other settings, it's absolutely critical that you have inspectors that have a knowledge of those particular systems so they can reach a fair judgment.
Michael?
I agree entirely. I mean, I think the big worry for schools is that where you have an inspector who doesn't necessarily appear to understand the particular nuances of that type of school, is it comes across as a lack of preparation. It comes across as, in many ways, as a hurried inspection, because nobody likes to be inspecting or talking about something that they don't feel that they've got a grip on. And it also comes across, Simon used the phrase predetermined outcome. It also comes across as though the inspector is just looking to go to move the inspection towards something that they've already decided or has been decided prior to the actual visit. And I think, and that then translates into a lack of empathy, doesn't it? And again, Simon talks about the lack of empathy, not all the time, but some of the time. So I think you have to have an inspection team that knows what it is looking at, that understands what it is looking at, and knows what the correct questions, what are the right questions here to ask about the curriculum that's being delivered, all those particular issues that the children might have.
I wonder on that, or more broadly, whether you think there is a case for greater legal regulation of Ofsted. Is this something, in short, that Parliament should be looking at, that the legislature should be looking at, to introduce whatever form of checks and balance may be necessary?
Well, I mean, I think there are always pros and cons, aren't there, to making something more rigid and perhaps to flow more through statute. But I think you should be careful for what you wish for, because whilst greater legal regulation seems superficially attractive, and perhaps gives a greater degree of certainty, it is more difficult to change and turn around if it's not quite working. So I think there has to be a balance, and perhaps the process of cultural change through amendments to the inspection handbook, through the safeguarding duty desk that Emma referred to, etc., the greater focus on well-being, of understanding the impact on schools and staff, and indeed the ability now to pause inspections if there is a albeit in exceptional circumstances, if there is an adverse impact on the mental health of the head and others. I think that's indicative of a step in the right direction.
I have a sense at the moment, this might be right or wrong, that Ofsted, who is undertaking its big listen, is maybe waiting to see what happens with a change of government, which after all may have some influence on its policy direction. It isn't under an immediate requirement to do anything more than it's done in the response to what happened sadly with Ruth Perry. It's not wanting at the moment to make radical change. It's waiting to see how things pan out. Is that fair?
I think you're right. There have certainly been a number of changes made in the past year, many of which are welcome. Also, as part of the big listen, I can see that changes will come through that process. I suppose in reality, from my perspective, and I think probably as we've seen from this conversation, this isn't over. There are still going to be a lot of changes that may well be around the corner, and they're obviously going to need to be considered post general election. So I suppose it may well be the case that we meet again.
I mean, I think ultimately it will be very interesting to see what comes out of this big listen. We've talked about, should there be greater regulation in terms of Ofsted, and I was talking about being careful what you wish for. I think that it does remain startling, in my opinion, that there is no appeal process against an inspector's judgment, and as long as that remains, there will be a lot of unhappy schools. And I think that is something that you need to look at, but consider, of course, the balance of the importance of getting the published judgment out, so parents, Emma talks about, parents are interested in what their local schools stand for and how they provide. So you've got to balance the importance of a judgment being published relatively quickly, because it's a snapshot in time, but also balance the fairness of that. Of the impact of that report on the school, and allowing the school a proper route of challenge.
All right. Well, for the moment then, Michael Brotherton and Emma Swann, thank you very much for cross-examining with me today.
Not at all. Thank you, Tom.
Thank you, Tom.
Well, we've reached the end of the podcast, but we'll be back soon, and we'd love to know what you'd like us to examine next. Tell us what you're interested in or concerned about in the world of law by tweeting at CrossExaminePod, or by visiting our website at www.crossexamination.co.uk. Remember to follow us wherever you get your podcasts, and if you've got time, we'd love a positive review on Apple Podcasts. It's the best way to spread the word about cross-examination. Meanwhile, I've been Tom Cross, and until next time, goodbye.